Alex here with part 111 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. It's a video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. That's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We are going now into the judge's order after hearing. I think I could have had a pretty negative mindset at this point, but I really I wasn't surprised because it was a stipulation in the end anyway. We came to an agreement in the end anyway. And so there was nothing that I expected, that was going to be in this order that was going to do, any more harm that had already been discussed at the hearing. And at that point in time, the only harm that was discussed was I think it was $500 or $600 in attorney fee award. This is the one that gets through. I think I've talked about this before in a number of videos where my ex's attorney files somewhere around 6 or 7, maybe 8 motions for attorney fees, and only one of them gets through. That's the one that gets through. And I was able to get a substantial discount. It was somewhere between 25 and 40%, I think, somewhere around there, on that attorney fee request. And the only reason I was able to do it was I was able to leverage the fact that I thought I would be able to overturn it on appeal in negotiations, and so I was able to negotiate it down below the 50% mark. So, it's not a great thing to get in the mail an order after hearing that isn't going to be, changing the situation at all for the better. At least that's how I felt back then. I'm going to go ahead, of course, go through it line by line, and maybe, my opinion now is different all these years later. In fact, I recall when I watched the actual hearing video, it wasn't as bad as I imagined it would have been, and it wasn't as bad as I imagined it was back then. It's funny how your memories sort of play tricks on you, especially over 10, I don't think it was 10 years. I think it was like 9, maybe 8 years. 2013, 2014, something like that. So I think at this point we can go ahead and we can take a look at what the judge has found. Here we have the judge's order after hearing. I'm going to go ahead and scroll right into the introductory paragraph, which indicates that we came before the court on my motion, January 23rd, 2013. I appeared in proper person. My ex appeared through and by her attorney, Kathrine Berning. This is a stipulation. Well, it was still prepared by the attorney, but it was a stipulated decision because we both at the hearing decided to go ahead and settle that. And you'll notice here that the judge wrote in based on the agreement of the parties, and he initialed it Chuck Weller. The reason that he did that was because he wanted to make sure that it was clear that this was an agreement between myself and my ex, and that neither side won or lost. And there's implications there that have to do with whether you can appeal a decision, and also even whether you can seek a motion for attorney fees or costs, claiming that you are the prevailing party on a decision. So he's just making sure that none of that nonsense occurs by stating, or at least by including here, that we agreed to this being done, and therefore there is no prevailing party, there is no winner, there is no loser, nothing was granted, nothing was denied. It's just an agreement that we came up with. By the way, guys, I should have probably dealt with that in an objection to a proposed order. The written order is what controls what actually occurred, and so it's important to not just assume that you'll be able to fall back on a video. It's better to make sure that that written order is actually consistent with what occurred in the video. As you can see here, I didn't file an objection to my ex-attorney's proposed order. I just let it through. I just assumed that this was correct. And I got lucky because the judge read it and changed it. But a lot of times the judges don't change it. A lot of times the judges don't even read it. And in fact, if you want to know more about that, definitely watch the video, Proposed Orders. So next we have that my ex and I will continue to share joint legal during physical custody, that our son's homework packet shall travel with the child. Now, like I said earlier in the video, I think my mindset was mostly negative and that I didn't feel perhaps at the time that I got anything substantial. But now in hindsight, looking back and knowing that this homework packet led to my ex being held in contempt of court, I can say for sure that this small victory was a large piece of the puzzle going forward. In fact, I don't think it'll be long before we get to the next hearing in this case and you will see that this specific portion of the order is what she violates and that this is what causes the judge to hold her in contempt of court and put her in handcuffs. Going into the next section, we have that each of us is responsible for ensuring that our child's homework is completed, of course. Next, we have here that forwarding the cost of the minor child's school. Oh, okay, so my ex is ordered to pay half of the tuition fees. Then we have the attorney fees to my ex's attorney in the amount of $650. By the way, guys, she was required to file a Brunzel affidavit until I settled. Once I settled, none of those additional requirements imposed by law matter because we came to an agreement. And so I do not believe that she will be filing a Brunzel affidavit in this case at any time. I think that this specific order completely takes care of that issue. Next, we have that we agree to waive any appeal rights relating to this issue pending before the court, and that my motion for reconsideration is withdrawn, which is true. And then the last thing here is the penalty for violation of order, which is the standard boilerplate language indicating that you can't run off with your child in violation of the court order or you're committing all these crimes. Certificate of mailing, which is indicating that the administrative assistant who works for the judge has mailed this document to me at this address and has submitted this document to my ex's attorney electronically. Here we have a notice of entry of order. I've talked about this before. In fact, I talked about this in the previous video. Same thing that I mentioned in that video. Please make sure that you go into the video notice of entry of order and watch it because that's where I contain all of the details as to what this is. Certificate of mailing under Rule 5 indicating that this document was served to me. By mail, I believe. Yes, by mail. Affidavit of Melissa Richardson. Okay, so this is probably one of the things that was supporting... Oh no, this is... One second here. Yeah, okay, so guys, this is a short affidavit. I'm not going to read through it line by line like I usually do with affidavits. I'm just going to highlight right here, number 5. I know what this is. Earlier, about a minute ago, I thought that this might be something that was filed late, that was actually used in the previous hearing or was intended to be used in the previous hearing. But in fact, having taken a closer look, this is me basically building this case up for yet another motion to modify custody. Only this time I win. This affidavit is one of several that is going to be filed over the course of time. And that what I'm doing here is I am putting together a case against my ex. Ideally, I wouldn't have filed these ahead of time because it just is going to give your ex or your opponent more time to strategize and figure out how to deal with this problem. But at the time, I really didn't want this to be about litigation. I wanted my ex to see that I was ramping up a case so that she could take care of our son's teeth. I, at this point, had gotten so used to the fact that she responded to force, legal force, that I thought to myself, well, if that's what it's going to take for her to not let all of his teeth fall out, fine, I'll go ahead and do it. And so I would file these documents and I would tell her attorney, hey, here's an affidavit. If we go to a hearing, this is what I'm going to use. Not because I want to brag or show off or intimidate her, but because I want her to actually solve the problem. So I think anyone who's been watching my channel long enough knows that this problem does not, get solved eventually. Not at all. Our son does end up needing 5 crowns, 2 extractions, and this does end up going to a hearing on, motion to modify custody again. But this time I do win that motion. We're going to get to that point. We're going to talk about that a lot more when we actually get to the hearing video. But I will say that this here is an affidavit from a friend who is stating under penalty of perjury that our son has 2 extremely large infected-looking cavities in his lower rear molars. And that isn't going to be the best one. I think we have a couple more here. Next document is an affidavit of preschool owner. This is the owner of our son's preschool. And again, this is going to be in line with the previous affidavit, which is going to have to do with the dental neglect that my ex is committing. And I'm going to go ahead and skip through the first few sections. These are pretty much always the same in all of my affidavits. So if you've seen one of my affidavits, you've pretty much seen them all. At least with those first few sections. So here we have the statement that on the 28th of May, the It was brought to her attention that our son was experiencing pain. She communicated with him, and he indicated that his tooth was hurting. Upon closer examination, he was visibly distraught, crying, and in obvious pain, and that she observed 2 extremely large infected-looking cavities in his lower rear molars. He was in pain for an excess of 1.5 hours, and she was very concerned that he was in so much pain and for such a long time. She's swearing here under penalty of perjury that the foregoing is true and correct. Hey guys, if you want to get the distinction between declarations, affidavits, and just like a letter, please take a look at my video, because I think it's titled literally letters versus declarations or something like that. Anyway, in that video I explain why this can give you a little bit more oomph if you file it with the court, because it makes it clear to the court that this person here wasn't just, handing a letter over to a parent, that it was clear to them that it was going to be used in a court of law. Just makes it a little bit more serious. It makes it so that it's more likely that they carefully read it. These are concerns that a court has. Ultimately, they have to appear and testify at the hearing that comes up anyway. So, of course, they're going to still be subjected to cross-examination, at least in our state. Please don't take that for granted. Other states have exceptions. In fact, please take a look at my video, hearsay exceptions. But again, guys, if you want to learn the distinction between letters versus affidavits and declarations, take a look at that video that I mentioned earlier. And of course, I wanted to mention one more thing, that this bold italicized text right here where it says, "I declare under penalty of perjury that the foregoing is true and correct." That phrase is described verbatim in the Nevada Revised Statutes, and it has to be word for word that exact phrase for its power, I guess you could say, to take effect, which is to not basically get you around the requirement of having to go and find a notary, paying the notary, getting them to stamp it, and putting their seal on it and putting it in their little book and stuff. It saves you time, it saves you gas, it saves you money, it saves you time. It's just easier to do it that way, and it's described in that video. Affirmation. This affirmation is indicating to the clerk of the court that this document does not contain the social security number of any person, and here we have my certificate of Rule 5 service indicating that I mailed this document. Oh no, I personally served this document upon my ex's attorney, which means most likely it was one of the staff members behind the counter. Another affidavit here, this one is by a preschool provider. So the other one was by a preschool owner. Here we are, preschool provider, and first few lines are the same as all the other affidavits for the most part. We're going to go ahead and skip to 5, which is that on the 28th day of March, she noticed that our son was experiencing oral pain. She communicated with him, and he indicated his tooth was hurting. Okay, so this is the same, almost the same. Actually, this looks the same, like verbatim, as to what the preschool owner swore to. And then the next line is also the same. So same exact affidavit, guys, just another witness or potential witness, basically. And we're going to go ahead and move on here to the Rule 5 Certificate of Service. Again, indicating that this document was served upon my ex's attorney personally. Moving on, going into the aftermath, I filed, let's see here, 1, 2, 3. Looks like 3 documents. Those are all free filings, actually. So they should have been. Yeah, they're free filings, so I incurred $0 in costs. My ex's attorney filed 1 document and notice of entry. That's also a free filing, so she incurred $0 in costs. The final document was filed by the court. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, let's see. For the notice of entry, probably 5 minutes. It's a standard document. Normally, I wouldn't put much time into the things that I file, but these were 3 affidavits from 3 potential witnesses, so it's possible that she did at least read them and send them to my ex. Maybe she even said something like, "Hey, you should take care of his teeth." I think it's reasonable to say 5 minutes each under the circumstances, because number one, those affidavits are from disinterested parties, so that's a concern for an attorney, because it's a more serious witness. I don't know, I think 5 minutes each is fine, so that's 5, 10, 15, plus the other 5 for the notice of entry. That's 20 minutes total so far. The order after hearing, she prepared this order that would have taken more time than just, a sort of cursory review, as if the judge had prepared and filed it. She had to prepare the order, and I guess she would have had to review it, because, sometimes there's changes, and in this case there was, because of the line that he added in there. I'm kind of leaning towards 20 minutes, maybe 25 minutes to prepare it and review it. It's not very long, so I think that that's going to go ahead and work. So 25 minutes for her to prepare that order, 20 minutes for her to review the other 4 documents, brings her to a total of 45 minutes, which should come to 125 plus 62.50. That should be 187.50 if I'm correct. If not, the panels will be correct. $187.50 in attorney fees for my ex. And I think that's it, guys. If you have any questions, feel free to post them down in the comments below, and I will see you guys next time.